Ladies and gentlemen, jury service may be strange to some of you, and so a short explanation will be in order before we start the trial. Those who participate in a trial must do so according to established rules. That's true of witnesses, the attorneys, the judge, and the jurors. The lawyers will present the evidence according to those rules, and the judge is the one who enforces those rules and determines what evidence may be admitted. Now, as jurors, you will be the sole judges of the facts, credibility of the witnesses, and the weight we give to the testimony that you'll hear. And at the end of the case, the court will instruct you on the law regarding that, and at that time, then you'll apply that law to your fact-finding. It's your sworn duty as jurors to accept the law as given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys are going to outline what they expect the evidence will be. These are called opening statements. Opening statements are not evidence or argument. They're just simply a preview, if you will, of what they believe the evidence is going to be. And it's designed to help you follow the evidence as it's presented. Next, the state of Ohio will present their testimony and evidence. And then after they complete presentation of evidence, then the defendant may, but is not required, to present evidence. If the defendant does present evidence, then the state may, but is not required, to present what's called rebuttal evidence. Then after that is concluded, the court will instruct you on the law regarding the issues in the case. You'll hear the closing arguments of counsel at that time, and then the court will finalize you the instructions with the instructions on how to deliberate and return verdicts. And then you'll consider the case and make your decision at that time. Now, procedure for questioning witnesses is as follows. Party who calls a witness asks questions first. That's referred to as direct examination. The opposing party then has the right to ask questions. That's called cross-examination. And then after that's complete, the party that calls the witness can ask additional questions about only what was raised on cross, and that's called redirect examination. Jurors are not permitted to ask questions. Now, during the trial, it's likely attorneys will make objections. That's the procedure by which an attorney raises a legal issue that must be decided by the judge. And so if I, after hearing the objection, say that it's sustained, then that means that I've determined that the objection was well taken. And it would most likely be to testimony or questions are asked for witnesses. So if I say it's sustained, that means either the question or the answer, expected answer, or both have been determined to be improper. If I say overruled, that means that both the question can stand and the answer can be given. Now, occasionally, because we're all human, people talk fast, people talk over each other, and sometimes a witness answers a question before the attorney can get objections stated on the record. And if that happens, and I determine then that either the question or the answer or both were improper, then that means that testimony will be stricken. That means you won't be able to consider it. Now, we know you're not computers where you can simply wipe it off and say it's gone. But the way that works is this. If you're when you're in the jury room deliberating, if someone brings up that statement that was stricken, you have to say, no, we can't consider that because it wasn't proper. So we had to put that aside and not talk about that at all. Now, I may also say that you're to disregard that testimony in addition to, or as an alternative to strike. It means the same thing. That evidence is not to be considered. Now, it's important that you be fair and attentive throughout the trial and listen to what's being asked and being said. And it's also important that you abide by all the other instructions the court's giving you. One of those is that you're not to discuss this case with anyone, including among yourselves, during the breaks. And you might think, well, why can't we talk about it? Because we're the jurors. Well, you are. But until you have everything that consists of a trial, it's not proper for you to talk about it or to try to make a conclusion. So you have to have all the evidence. You have to have the argument and opening statements of counsel. You have to have the instructions of the law from the court on both the legal issues as well as the deliberations. So until you have all that, it would be improper for you to discuss this matter, even if it's just two or three of you having lunch together or sitting in the jury room or walking around together. So you're not to do that. You must also explain this rule to any family or friends you may come in contact with during the trial. So, for instance, at lunchtime, if you meet somebody for lunch, or you have to run into somebody, or if you're going to call home or call work. Again, you have to tell them, I'm not allowed to speak about this until after the case is completed, at which time you're released from that restriction. Now, you're not to talk, as I indicated earlier, with the attorneys, parties, any witnesses, or any other person about the case, and the other persons are not to talk about it in front of you. Now, sometimes people may be aware of the case, not realize you're a juror, so if you hear somebody talking, say, hey, here's my jury badge. Please don't talk about that. And if they won't stop or they won't move away, then you move away from there so you don't hear what's being said. You're not to investigate or attempt to obtain any information about this case outside the courtroom, so that includes particularly looking up anything on the Internet on it, because now with the Internet it's easy just to go on and type in something. And so if during the trial you hear about a topic or something that you think, well, I want to know more about that, you can't do it during the trial. After the case is over, there's a verdict, yes, but during the trial, no, because that way you'd be finding something that's not in the record, and that would be improper. Now, if you feel that something's happened, that something's been said to you, or someone's talked to you, or think that it may be an issue, don't just report that to the bailiff, and he'll report it to me, and then I'll discuss it with the attorneys and decide what may need to happen. I've also, as indicated earlier, I'll instruct you again and more thoroughly, you're not to read or view or listen to any kind of a report about this case during the trial. So that means don't look on, most likely that's on the Internet. People post on the Internet almost instantaneously. And now that the papers have those as well, they may post as well. And we do broadcast this on YouTube, so people don't have to be in the courtroom to watch. They can go ahead and watch it on YouTube and post while they're watching. You're not to look at any of those posts. If you are a person who is active on social media, do not post anything about your service on the jury during this case. Wait till it's over if you're inclined to do that. It's up to you. But during the trial, don't put anything on any social media, either personal account or responding to any other person's account. And because, again, if that should have happened, then you again need to inform the bailiff. And I will also tell you that in the event that something should happen that you think you need to report to us, we may need to ask you about that. And for that reason, I tell people don't ask the opinion of a fellow juror or jurors, because anyone you talk to can also have to be questioned. And I give this example about 25 years ago or so, maybe longer. Probably was longer because I believe Judge Hottle was the judge. We had a fairly long trial. We had 15 jurors, 12 jurors and 3 alternates. And at lunchtime, one of the jurors ran into somebody that knew, and they blurted out something about the case to him. So they came back, and instead of telling the bailiff, they went back to the jury room and said to the other 14 jurors, well, this is what happened. I guess I need to report that. And they said, yeah, you need to. Well, because he had brought it out, I can't remember if it was he or she, but whoever it was that brought it out, we ended up spending an afternoon bringing 15 jurors in one at a time and asking them questions, and that took most of the afternoon, so we lost a half a day of trial. And so if you have any doubts, err on the side of caution, tell the bailiff. Now, from time to time, you'll see bench conferences like we did when we chose a jury. The attorneys will come up here and talk to the court, and you'll hear the static. And that may be to argue a point of law about an objection, and for that we don't want all that stated in front of the jury, because if I ultimately decide that it's not permissible to have that in there, then that's more stuff you have to disregard. So we're trying to avoid you having to forget or not consider things that you hear during the trial if they were not proper. Okay. So that completes the instructions of the court, and you're to obey all of those. During the breaks that we'll have, we'll be breaking, for lunch at about noon, somewhere around there. I don't have a strict timetable. I try not to break in the middle of something, but sometimes we have to. But during any breaks for lunch or for recesses, you're going to obey all these laws, all these instructions, and I'll say something like, "Remember the admonitions or instructions of the court." That means obey all of those. All right, with that, now we're going to hear the opening statements from counsel, which is, again, as I just indicated to you, are not evidence. or argument, but are simply a preview, if you will, of what they believe the evidence is going to be during this trial. And they're designed to assist you in understanding that evidence as it comes in. Ms. Collins, on behalf of the state.
Thank you. May it please the court, Mr. Blosser, ladies and gentlemen of the jury, today the state will present you with the evidence that proves that this man, Christopher Burns, worked with Joey Fender or was complicit with Joey Fender in selling methamphetamine to an undercover informant working with the Highland County Task Force. Lieutenant Chris Bowen, Investigator Justin Brewer, Detective Brian Butler, and Sergeant Jay Beatty run the Highland County Task Force, and one of their main jobs is to eradicate Highland County of illegal drugs. In doing that, they often work with citizens who are able and willing to buy drugs off of drug dealers. One of those undercover citizens was Bobby Gibson, and one of the people he was able to buy methamphetamine from was Joey Fender. On June 29th of 24, Bobby set up a deal with Joey to purchase 2 8-balls of methamphetamine for $120. Now, you will learn during this trial that 8 balls is a slang for a weight, and it means 3.5 grams. Each 8-ball would be 3.5 grams of meth, or 1/8 of an ounce. Bobby was searched to give him recorded buy money, an audio recorder, and a video recorder. He was driven to the home of Joey Fender by Investigator Justin Brewer, and that home was on Bell Street here in Hillsborough in Highland County, Ohio. While Investigator Brewer waited in the car circling the block, Bobby walked into Joey's home. Joey was in her home with the defendant, Christopher A. Burns. You will see on the video that when Bobby walks in, Joey directs Chris Burns to get the stuff off the dresser. He turns around, he fiddles around on the dresser, he's looking for things, they're kind of bickering back and forth. He gathers up the bags of white substance, and as soon as he does this, he turns around and he hands them to Joey, and that's all on video, so right then he possessed the methamphetamine. He then hands Joey the meth. She takes the meth to the other side of the room and asks the defendant to find her the scales so that she can weigh it and make sure that it weighs 7 grams in total, 3.5 grams for each 8-ball. He looks around the room, he searches the dresser until he finds the scales, and then this defendant takes the scales to Joey so that she can weigh the meth. He has aided and abetted her in selling methamphetamine to Bobby Gibson. He's complicit. She weighs out the 2 8-balls, she hands the meth to Bobby. Bobby gives her the money, he ties off the bags. Then he leaves Joey's apartment, or Joey's home, and he returns to Justin Brewer's vehicle. Investigator Brewer then drives back to the meat place where he meets with Detective Butler. Again, they search. Bobby turns over the meth, he turns over the audio and video recorder. They search Bobby again. Now, during this deal, Detective Butler is sitting in a vehicle stationary, and he's watching the entire thing live as it's happening. The audio video recording device that they use allows Detective Butler to live stream it and to watch it as it's taking place. The 2 bags of suspected methamphetamine are sent to BCI, which is a crime lab here in Ohio, where it tests positive as meth in a weight of 5.90 grams. So just a little less than the 2 8-balls that Bobby requested. You will learn from the jury instructions that bulk amount of meth is 3 grams. So this was greater than 3 grams. Ladies and gentlemen, these are the facts of the case. The evidence I have described you will see and hear today. You'll have the audio and video of the deal, the bags of meth, detailed notes of the deals, as well as the testimony of everyone involved. You will hear from Investigator Brewer and Detective Butler, whose primary job it is to oversee deals like the one you will learn about today. You will hear from an expert from BCI, whose only job it is to test and weigh suspected narcotics. And finally, you will hear from Joey Fender and Bobby Gibson. Bobby will explain how he arranged to purchase the meth from Joey and how Chris Burns helped her with that deal. You will learn that Bobby Gibson was actually paid for his work with the task force, just as he would have been with any other job. You will hear from Joey Fender that the defendant was at her house, and this was not an uncommon thing, he was there daily, and that he assisted her with packaging the meth for sale, and that was not uncommon. After you hear the testimony and review the evidence, I am confident that you will find the defendant guilty of all counts. Thank you.
All right, thank you. Mr. Blosser, on behalf of the defendant.
May it please the court and counsel, ladies and gentlemen of the jury. As stated, opening statements are just that. They're just statements. They're not arguments and they're not evidence. You've heard what the state expects the evidence to show in this case. And you folks will be the sole triers of fact. You listen to the witness testimony and any other evidence that's submitted, and you'll make that decision. Now, typically, my opening statements are very brief. Okay, like I said, they're not arguments, and we don't have a burden of proof in this case. So, what we expect is for you to weigh the credibility of the witness's testimony. And then when you're able to do that, apply the law as it's applied to you, as it's given to you by the judge. And we're confident that in doing so, you will find that this case was not proven beyond a reasonable doubt. And you will make the correct decision during deliberations. Thank you.
All right, thank you. Counsel, would you approach? I need to put a couple things on record. Can you give us some static? No, we're on the record. Just give us static. Yeah, right. All right. Pam Farley. Were you sworn in the clerk's office?
Yes, sir.
All right. If you have a cell phone, make sure you turn it off, please.
Yes, sir. If you grab that.
Pull that microphone clear over to your left. Speak into that, if you would, please. All right, Jermaine, where?
Please state your name for the record.
My name is Pamela Farley.
And Ms. Farley, where are you? What's your current occupation?
I'm a forensic scientist.
And where do you work?
I work for the Ohio Bureau of Criminal Investigation, which we call BCI for short.
And what section of BCI do you work in?
The drug chemistry section.
How long have you been employed with BCI?
Just over 7 years, since 2018.
And what's your background in education?
I have a Bachelor of Science degree in forensic science, which I obtained from Defiance College in 2008. Most recently, I have a graduate certificate from Bowling Green State University's online campus in quality systems.
Do you complete any sort of training or anything like that at BCI?
Yes.
And how often do you complete that?
Prior to being signed off for casework, an employee has to go through a probationary training. Typically that's 6 months, but previous work experience at a different crime laboratory truncated my training to 3 months.
And have you testified in court before?
Yes.
Do you know how many times or about how many times?
Just about 30 times.
Have you previously been qualified as an expert in substance identification and measurement?
Yes.
Have you completed any sort of testing? I'm sorry, strike on, I already asked you that. Have you been successful in the testing programs that you have completed with BCI?
Yes.
At this time, I would ask the court to declare Pam Farley an expert in forensic chemistry.
Objection required.
No objection.
I should so declare.
Does BCI have a written procedure manual for substance identification and measurement that you follow?
We do.
And did you follow lab protocol in this case?
Yes.
Now, when you receive an item into the lab for testing, what steps do you follow?
The evidence is hand-delivered by law enforcement agencies, and they work with our evidence intake technicians to enter all case information into our laboratory information management system. We call that LIMS for short. That's a computer database program that we use to enter case information in, and that's also where I enter in my analytical findings and my report of analysis. The officer or agent will sit with their evidence intake technician. Evidence is entered in. Each piece of evidence is associated with a case number, and they all get electronic barcodes attached physically to the evidence. We scan that while it's in the laboratory so we know where it is at any point in time.
And with this particular piece of evidence, did you take that personally from the intake section?
Once it goes through intake, it remains in a secured access storage area where I will then retrieve that and take it into my personal custody, where I will then begin testing on it.
And when you begin testing, how do you begin your analysis?
I will physically scan the evidence to my custody, and then I will take a visual inspection or an inventory of the evidence to make sure seals are intact and no tears or holes are present in the packaging. I then go into our LIMS program and I start entering case information, including a description of the packaging, a description of the evidence itself. I'll collect a weight of the material, I'll enter my dates of analysis, and then I enter my analytical results of testing.
Now, what sort of testing do you do on something to determine the identification of a substance?
We have 3 possible tests that we can perform. 2 are required. A preliminary exam is required. It provides some information about what type of compound may be present, but not enough to confirm something. And the other required test is a confirmatory test. We are required to have that in order to positively identify a substance if it's present.
And what's that test called?
The preliminary or the confirmatory?
The confirmatory.
I used mass spectral testing on that.
And do you follow the same steps in every single piece of evidence that you get?
Each case is different, so the type of testing that performed isn't always the same, but the testing that I use in this case is very common with forensic chemistry analysis.
And when you strike that, is the method, this mass spectrometry and gas chromatography, are these approved and accepted by BCI?
Yes.
Do you complete a report in association or as you are doing your examination of the chemical?
I do.
May I first?
You may.
I'm handing you as previously been marked as States Exhibit 1 for identification purposes. Do you recognize that?
I do.
And what is that?
This is a copy of my report of analysis.
Is that the report of analysis, and how long are you able to tell when you receive that evidence, and are you familiar with the case that is in relation to?
Yes, we have a submitted section which lets us know when the case is submitted to the laboratory for testing.
And this is a report that you prepared in relation to your testing in this case?
Yes.
And is it a sort of report that you would generally prepare in your course of business in relation to testing at BCI?
Yes.
When was the evidence received by the laboratory to your report?
July 12th, 2024.
I'm next going to give you a previously marked as States Exhibit 2 for identification purposes. Do you recognize that?
I do.
And how do you recognize that?
It bears a BCI barcode for the case as well as the item, and it has my initials, date, and then case number and item number present on it.
And is that the chemical that you have tested and outlined in States Exhibit 1, the report?
It is.
Now, did you use the previously discussed testing methods to determine the substance it contained in States Exhibit 2?
I did.
And what were the results of your analysis?
Would you like me to read the entire findings?
Just the type of chemical that it was at this time.
Methamphetamine?
Now, do you do some sort of testing procedures to ensure that your testing is accurate?
We do.
And what do you do?
We check our balances weekly to verify that they are measuring appropriately, and those are also calibrated annually by an approved outside vendor. Our instrumentation is also subject to weekly, monthly, and yearly controls to ensure that it is testing properly.
And was this testing done properly in this case?
It was.
Now, in your expert opinion, based on your testing, education, and experience, what is the substance contained in State's Exhibit 2?
Methamphetamine.
And do you then weigh the substance?
The substance is weighed when I begin my analysis.
So when you weigh it, it looks like it's in a couple bags there. Do you weigh it in those bags?
No.
And so how do you tell us how you weigh it?
The material is removed from any exterior packaging that it is received into the laboratory from. So the weight of the material is, on the report, is the weight of the material itself with no packaging.
So in your expert opinion, based on your testing, education, and experience, what is the weight of the substance contained in State's Exhibit 2?
5.90 grams plus or minus 0.05 grams.
And did you record that on your report outlined in State's Exhibit 1?
I did.
And what did you do with this evidence after you analyzed it?
It is securely sealed. We commonly use a heat seal to ensure that no holes are present in the packaging. It is then transferred back to that secured access area where it will remain there until the agency who submitted it comes to collect the evidence.
I have no other questions.
Cross.
Thank you, Your Honor. Good morning.
Good morning.
So you merely tested the substance, is that correct?
Yes,
And so you did not witness the alleged sale of the item that you tested, or items?
correct. I did not.
You cannot testify as to whether or not it was Mr. Burns who sold the items that you tested, is that correct?
Correct.
And you also cannot testify as to whether or not Mr. Burns even handled the items that you tested, is that correct?
Correct.
Okay, no further questions.
Read the record.
No, Your Honor, she's
Right. You
excused.
may step down. Thank you. Next witness.
Bobby Gibson. Ms. Farman.
Bobby
You're
Gibson.
excused. You may leave.
Were you sworn in the clerk's office?
Yes, it was.
Have a seat over there, please. Slide that board over in front of you after you sit down. That's got the microphone on. Please speak into that.
Slide.
If you have a cell phone, make sure it's turned off.
All right.
All right, you may inquire.
Mr. Gibson,
Yeah.
you want to set up and you're going to have to talk really loud.
Oh, I'm sorry about that. I've been sick for about 10 days here, 12.
Can you please state your name for the record?
Robert Gibson.
And Mr. Gibson, have you watched any of this trial on YouTube?
No, I don't got YouTube.
Do you have any felony convictions within the past 10 years?
Yes.
What?
Manufacturing the drugs and aggravated possession of drugs.
At some point in 2024, did you make contact with members of the Highland County Task Force about doing undercover work for them?
Yeah.
And were you able to start working for them?
Yes.
Now, did you initially start working in order to work off charges?
Yes, is what they said.
What does that mean? What does it mean to work off charges?
That's what it means. We're off the charge.
So you thought you were going to be charged with a crime?
Yeah.
And you did work for them so that you wouldn't be charged?
Yes.
After you completed that, did they start paying you for buying drugs?
No, they paid me right off the rip.
So right from the beginning, they started paying
Yeah.
you. And did you provide the task force with the names of people that you could purchase meth from?
No, I didn't provide them names. I just, when it come, someone that was there to get it from, that's when I gave them the name. I didn't say, go out and say that Joe and all these guys got meth and want to sell it. No, I didn't do nothing like that.
But you-
I just, when I run into someone who wanted to sell something, they wanted to buy it. I told them the name.
So you would tell them who you could set up a deal with?
Yeah.
Okay. Was one of those people Joey Fender?
Yes.
Going back to June 29th of 24, do you recall setting up a deal with Joey Fender?
Yes.
And how was the deal arranged?
I told her I wanted 2 8-balls,
And what's an 8-ball?
3.5 grams apiece,
Do you remember how much you were going to pay for those 2 8-balls?
$120.
And prior to the deal, were you searched?
Yes.
Who searched you?
The officers.
One of the task force
Yeah.
officers? And when they searched you, tell us about that. Is it just a pat down or they pretty thoroughly search you?
thoroughly search you, make you take your shoes off, and get you out and pat you down and all that stuff.
Were you provided with money
Yes,
to complete the deal?
yes,
And were you provided with an audio and video recorder?
yes.
Were you driven to Joey's home?
No, I was dropped off and I walked from a certain point.
Pretty close to
Yeah.
Joey's home? Who was driving you? Do you recall?
That day there, I think the beardy faced guy, I don't even know who he is.
Would Investigator Brewer seem like the correct name?
It was,
Justin?
yeah,
Did you enter Joey's home?
yes,
Did you recognize the people in her home?
yes.
And who did you see in her home?
I seen Terry right outside the house in a car, and a Joey and a Seaboat.
Who's Sibo? Is his name Christopher Burns?
Yes,
Is Sibo a nickname that you know him by?
I just call him that. I don't know.
And you see him in the courtroom this morning?
Yes.
Can you please point him out for the court?
Terry,
Please let the record reflect the witness has identified the defendant.
So ordered.
Did you use the audio and video recorder while you were there?
yes,
Did you see anyone hand anything to Joey?
when I was in there to buy it off Joey, she didn't have enough. She hides it all over the place in her house, everywhere. And she asked someone to get the scales, and then she said something about, I think it was something like, can you get my dope? And Sebo handed her the dope, but he didn't buy nothing from me. He just gave her, and she bought it from me. There's what happened. He didn't buy nothing.
So you saw Sibo hand the dope
It was Joey's dope.
to Joey.
It was Joey's dope.
Okay, answer my question. Did you see Sibo hand the dope to Joey? Yes or no?
I seen him hand,
Yes or no?
I don't know if it was the dope or the scales, ma'am, okay?
Did he also hand scales to Joey?
Yes.
Okay.
But he didn't buy that from me. It was Joey's. I handed her the money and everything.
After Joey weighed the dope, did she give it to you?
Yes. I had
And,
to tie it up and everything. She don't even tie it up.
and what did you do with it? What did you do then?
Tied it up, and I took it and left. I left and went and met the dude across the way there, the car, and gave it to him.
And when you got back in the car, what did you do with the meth?
I gave it to the officer.
Did you then meet up with Detective Butler again?
We always go. I get patted down again.
So you were
Then-
searched again after the deal?
Yeah, and then they recorded me and asked me what I'd done and all that.
And do you recall how much you were paid by the task force to complete this deal?
They gave me $200.
No further questions.
Ross?
So, how did you first become a confidential informant?
I was doing a year in the county jail for driving under suspension, and somebody come into county jail and said that they heard Taylor Jenkins. That's what they told me.
Objection, hearsay.
Yeah, I'll sustain that. Don't say what anybody said. Just tell them how it happened.
Without telling
you
us what
did.
was said.
I got informed that I was under
Objection.
indictment.
Objection.
Okay, wait a minute. Mr. Gibson, you can't say what other people told you. Just tell him how you came. You know, if somebody said something to you, fine, but don't say what it was.
I
Just
thought I was
explain it.
under indictment, and I went and talked to them because I got medical problems. I didn't think I'd go make it back out.
So essentially,
Yeah.
your intent was to work with the task force to avoid getting into trouble yourself. Is that
Yes,
fair?
exactly right.
And on that day of June 29th, when you went to Joey's house, you went to Joey's house to purchase methamphetamine. Is that correct?
Yes.
And you, in fact, did purchase that from Joey.
Yes.
No further questions.
Redirect.
No questions.
All right, you may step down. Next witness,
Joey Fender.
Joey Fender.
Yes.
Were you sworn in the clerk's office?
Yes, sir.
All right, just have a seat over here. You would, please? Yeah. if you have a cell phone, make sure it's off.
I left it.
Okay. Speak into the microphone when you're answering questions. Keep your voice up, please. You may inquire.
Please state your name for the record.
Joey Fender?
And have you watched any of this trial on YouTube?
No.
And what's your current address?
129 Bell Street?
Is that here in Highland County?
Yes, ma'am.
Have you recently been convicted of a trafficking of meth as a result of a task force operation?
Yes, ma'am.
And were you given any consideration in your case? Well, let me ask this. Have you been sentenced yet?
No, ma'am.
Were you given any consideration in your case for your cooperation here today?
Yes, ma'am.
Did one of the charges that you were convicted of occur on June 29th of 24?
Yes.
And tell us about the arrangement of that deal.
Bob Gibson came to my house to purchase 2 8-balls,
And do you remember how much he was going to pay for those?
$120.
Did Bobby, in fact, come to your house again to pick those 8 balls up?
Yes.
And who else was at your house when Bobby arrived there?
Chris Burns and Terry Wright.
Was Terry in your house or was...
Outside.
Okay. And how do you know Chris Burns?
Neighbor, friend.
Do you call him a nickname?
SIBO.
And how long have you known him?
Approximately 7 years.
And do you see him in the courtroom today?
Yes.
Can you point him out to the court? Please let the record reflect the witness identify the defendant.
So ordered.
What was the defendant doing at your home on June 29th of 24?
He came there regularly.
Was he there almost every day?
Yeah, probably.
Um,
Every other.
when Bobby got to your home, can you tell us what happened?
He set the money down. I gave him the stuff. I asked for the stuff.
I'm going to stop you and have you start over. And instead of saying he, can you put their names in?
Bob walked in, asked me, did I have the stuff? And he said, where's the stuff at, or whatever.
And then what did you do?
I asked him, I weighed it up and gave it to him.
Prior to weighing it up and giving it to him, where did you get the meth from? Did you direct anyone to hand you the meth?
It was on my dresser. I asked SIBO to hand it to me.
So you asked SIBO to hand it to you from the dresser?
Mm-hmm.
Did he do so? Did he hand you it?
I'm not sure.
Ms. Fender, do you recall watching the video of this deal?
Yeah, I remember asking him to hand it to me. I don't know if he handed me the scales, or I thought it was the scales he handed me.
Do you remember watching the video of the deal, yes or no?
Yes.
Do you remember the part where initially you get the meth and you walk to the other side of the room?
Yeah, I go walk over to the nightstand.
And then do you ask for the scales?
Yes.
So if he handed you something before he handed you the scales, would that be the meth?
Yes.
Okay. Once you walk to the other side of the room to the nightstand, do you then ask him to provide you with the scales?
I thought I had them at that time, but no. I don't know if I had them at that point or not, but
So if he walked over to you with something after you asked for the scales, would it be the scales?
no.
Were the actions of June 20th, 2024, June 29th of 24 abnormal, or is it something that happens commonly at your home?
Regularly.
Including with Mr. Burns handing you the meth or helping you weigh it and things like that?
Yes.
I'm sorry?
Yes.
On June 29th of 24, did you knowingly sell meth to Bobby Gibson?
Yes.
On June 29th of 2024, did the defendant help you by handing you the meth and the scales?
Yes.
No further questions.
Ross.
Thank you. Good morning. Ms. Fender, I believe you testified that Bobby had entered your house, or Bob had entered your house, put money on the table. Is that correct?
The bed, I believe.
I'm sorry?
I believe he said it on the bed.
Oh, the bed. Okay. But he set down money. And the agreement was he was there to buy methamphetamine from you. Is that correct?
Mm-hmm.
And you did, in fact, sell him methamphetamine. Is that also correct?
Yes.
And you are receiving consideration for your testimony here today with regard to your case. Is that correct?
Yes.
No further questions.
Redirect.
Only a couple questions. Have you been sentenced yet?
No.
I'm sorry?
No.
So you don't know what you're getting
No.
for your testimony today?
No.
No further questions.
All right, you may step down. Thank you. Next witness.
Justin Brewer. Your Honor,
Yes.
may we approach?
All right. All right. Were you sworn in the clerk's office? Have a seat over there, please. All right. Make sure you speak your voice up, or keep your voice up, and if you have a cell phone, turn it off. You may inquire.
Please state your name for the record.
Justin Brewer?
Have you watched any of the trial on YouTube this morning?
No.
And are you currently employed?
Yes, ma'am.
Where are you employed?
Highland County Prosecutor's Office.
And are you assigned to somewhere full-time?
Signed full-time to the Highland County Task Force.
And what does the Highland County Task Force do?
Work to eradicate drugs from Highland County, assist local agencies and outside agencies as needed.
How long have you been employed in law enforcement?
About 3 years.
And have you worked on covert drug operations?
Yes, ma'am.
What is a covert drug investigation?
It's where a CI is used to purchase illegal narcotics from a dealer.
And about how many have you worked on?
Oh, hundreds.
What roles have you played in these investigations?
CI handler, surveillance. I've driven CIs to buys.
And through your role as a task force agent, have you become familiar with drug words and words they commonly use?
Yes, ma'am.
And can you tell us what a ball is?
An 8-ball.
And what is an 8-ball?
In this situation, it was meth.
Is it weight?
Yes, ma'am.
And how much?
3.5 grams.
And what is ice?
Methamphetamine.
Is it just a generic term for meth?
Street, yeah.
In 2024, were you working on undercover drug operations in Highland County?
Yes, ma'am.
And do you recall a deal that took place on June 29th, 24?
I do.
And what was your role in the deal that day?
I drove the CI to the area of 129 Bell Street, which is where Joey Fender lived.
And once you drove him to the area of 129 Bell Street, what did you do?
Once the CI exited the vehicle, I stayed in the area and conducted surveillance.
And how did you know that after the deal was completed, did you pick the CI back up?
Yes, ma'am.
How did you know when the deal was completed and to pick it back up?
Task force agents maintain a conference call, and in this situation, at least one officer will watch the video as it happens, live feed, and we instruct one another as it's completed and what steps to take.
Who was watching the live feed?
Detective Butler.
So the two of you are on a
Conference
call with each other?
Yes, ma'am.
Is he telling you what's happening as it's happening?
Yes, ma'am.
So when the deal's completed, does he tell you to go pick him up?
Yes, he stated the CI's leaving.
And now, once you picked up the CI, what happened as soon as he gets in the car?
I immediately took possession of the narcotics that he purchased.
Do you also turn off the audio video recorder?
Yes, ma'am.
I'm going to hand you what's previously been marked as State Exhibit 2 for identification purposes. Look at that. Do you recognize that?
Yes, ma'am.
And how do you recognize that?
This is the meth that was turned over to me by the CI.
What did you do with it after it was turned over to you?
It was placed in a evidence locker at the Highland County Sheriff's Office.
Now, did you send that, the bag within there, the bag that the substance actually came in, did you send that to BCI to be tested for fingerprints?
No, ma'am.
Why not?
BCI won't test for fingerprints on plastic bags.
And what about DNA testing?
Same scenario. They won't test for DNA.
No further questions.
Cross.
Forgive me, is it, what's your title exactly? Is it like
Investigator.
investigator?
Yes, sir.
I just want to be accurate. So Investigator Brewer, you actually did not watch the video in real time, is that correct?
That is correct.
Everything that you were told was relayed to you.
Correct.
Okay. Obviously, you weren't in the residence where Ms. Fender resides.
No, sir.
So everything that you're testifying to today is either told to you or provided to you by the CI. Is that correct?
Yes.
Okay. Nothing further.
Read record.
No further questions, Your Honor.
All right, may step down. Thank you. Next witness.
Put that up there. Your Honor, may we approach again?
May. Some audio-visual equipment here set up, connected. So we're going to take about a 10-minute break. This time I ask you just go back to the jury room, wait in the jury room, and remember all the instructions and admissions of court that I'll give you during the instruction period earlier. So this should take about 10 minutes.
Please rise.
seat, please. All right. Mr. Miller,
Yes, Detective Miller.
have you been sworn in? Raise your right hand. You solemnly swear the testimony about to give you the truth, whole truth, and nothing but the truth shall be God. See it right there. Man, Clark.
Thank you. Please state your name for the record.
Yes, Brian Butler.
And are you currently employed?
Yes, ma'am.
Where are you employed?
I'm a detective at the Hillsborough Police Department.
And are you assigned somewhere else?
Yes, I'm assigned to the Highland County Task Force.
What are your jobs there at the task force?
In the task force, my job there is to combat the ongoing drug activity in Highland County.
How long have you been employed in law enforcement?
Approximately 16 years.
Now, during your career, have you taken any specialized training in illegal narcotics investigations?
In illegal narcotics investigation specifically, I'm previously Clan Lab certified, which would be to stabilize methamphetamine labs, as well as certified to transport them to the disposal area.
Have you previously worked on covert drug operations?
Yes, ma'am.
What is a covert drug operation or investigation?
A covert drug operation or investigation is basically law enforcement will supervise a CI or confidential informant. They'll sign them up, brief them, ask them who they can buy drugs off of, and we will supervise them. We will provide them with the money, an audio recorder, and follow them to the person that either we say, hey, who can you buy off of, or we tell them somebody who's a known drug dealer, can you buy off of them, and they get a hold of them. Happens one of two ways. We supervise them into going and meeting with this person in various locations and monitoring the deal visually and through audio recorder. After the deal, the transaction is complete, we meet with the confidential informant and recover the narcotics and the audio video recorder. And then we have a brief and interview the confidential informant afterwards.
Now, about how many of these investigations have you worked on?
In the thousands somewhere, I have no idea.
And what roles have you played in these investigations?
During these investigations, I've done surveillance, I've completed the log, I've driven the confidential informant, I've even made hand-to-hand transactions and bought the narcotics from the suspects themselves.
Now, through your role as an undercover, when you were buying narcotics hand-to-hand from someone, did you become familiar with drug words that they commonly use in the drug trade?
Yes, ma'am.
And can you tell us what is a ball?
A ball would be referred to as an 8-ball or an eighth of an ounce of commonly referred to as methamphetamine in this area under this drug climate for Highland County.
What is ice?
Ice would be crystal methamphetamine or meth.
In 2024, were you working on undercover drug operations in Highland County?
Yes, ma'am.
And when you decide to work with a civilian on undercover drug operations, what is the procedure that is initially followed with them?
Procedure that we initially follow with them is we sign them up, we go over rules and what's expected of them, we go over possible dangers, set up safety precautions.
And do you tell them what their options are during the buy? You know, let's say if their safety word in question, what would you tell them?
Yes, we come up with a safety word. If something really goes bad during the deal, they get a gun pulled on them or something, or their life is in jeopardy, they would say the safe word, and then we'd engage and stop the deal and detain the suspect until we can figure out what we're going to do from there.
Do you pay CIs for their work?
Yes, ma'am.
And how does that work, just in general terms?
Just in general, we got a flat, pretty much a standard rate we've been using for a while. We'll pay the CI for a standard deal. That amount can go up depending on the amount of drugs we buy or the amount of people that are involved in the deal.
When you begin working with a CI, how do you decide who to attempt to buy from?
Usually we ask the CI who can you buy from, and we go from there, and then they try to make contact with them, and we set the deal up that way.
When you're doing a deal with a CI, do you immediately arrest the dealer as soon as the deal is over with?
No, ma'am.
Why not?
Because that'll reveal the CI's identity prior to us. If we want to keep using them, that'll reveal the CI's identity. That's why we don't arrest right away.
Before a CI does a deal, got the deal set up and he's getting ready to go, is there a procedure that is followed every single time?
Yes, ma'am.
Tell us about that.
Procedure that's followed is we meet the CI. The CI says who they want to set up the deal with. Sometimes they already have. Once the deal's set up, we search the CI, every deal, or the CI's vehicle if they have a vehicle. We provide them with an audio and video recorder, recorded cash money. We follow them to the deal location. Once the CI makes contact with the suspect, we supervise that. We watch through audio, video recorder, or visual surveillance. Once the exchange is made and the deal was over, we follow the CI, make contact, and disclose location. We search the CI again, recover the narcotics, and interview the CI.
And now, did you also cover the after deal procedure there?
Yes, after we recover the narcotics, yes, ma'am.
Now, if we have an undercover agent driving the CI, you wouldn't go through the car search?
No, ma'am.
Before each deal, you either photograph or record the serial numbers of the buy money, but why do that if you don't immediately arrest the dealer?
Because if we end up going in the house for other reasons or we do a search warrant, we can identify which money that we use to purchase these narcotics if they're still in the home by the serial numbers.
In June of 24, were you working with the CI known to you as JoJo?
Yes, ma'am.
Is that his real name?
No, ma'am.
And why do you give the CIs fake names?
We give them fake names to protect their identity through the process of when we're working them. Because when we pay them, we have to do a voucher to where we have to document that we're paying them. That's where we put the fake names at.
And did you go over the CI procedures with the CI when you signed him up?
Yes, ma'am.
And was the CI the Bobby Gibson that testified earlier?
Yes, ma'am.
Did he advise you that he could purchase meth from Joey Fender?
Yes, ma'am.
And how was the deal arranged?
When we met with him, he'd already had it set up. He'd already been over to her house and spoke with her.
On June 29th of 24, did you and Investigator Brewer, along with Bobby Gibson, conduct an undercover buy from Joey Fender?
Yes, ma'am.
I'm going to hand you what's previously been marked as State's Exhibit 3 for identification purposes. Do you recognize this?
Yes, ma'am.
And what is that?
That is the activity log I completed for this particular deal.
And is this a report that you completed as the deal was taking place?
Yes, ma'am.
And do you keep that as part of your records and your work with the task force?
Yes, ma'am.
Now, just generically and briefly, tell us about the deal that took place on June 29th, 24.
Yes, Bobby Gibson made contact with me, I believe, said he set up a deal with Joey Fender to purchase 2 8-balls of methamphetamine, which would equal 3.5 grams apiece, 7 grams total for $120. Bobby had obviously already set the deal up, so we met with Bobby in a disclosed location. We searched Bobby. Investigator Brewer searched Bobby and I gave Bobby $120 in recorded cash money, and Investigator Brewer gave him the audio video recorder. Bobby Gibson rode in the vehicle with Investigator Brewer. He drove him to the area of Joey Fender's house. I followed. I also watched the audio video recorder through a live feed on my phone. Investigator Brewer drops Bobby Gibson off in the area. Bobby Gibson walks to Joey Fender's house, goes in, makes contact with Joey Fender and Chris Burns. Can we talk about the video?
We'll get to the
Yes, ma'am.
Get to the video in just a moment. I'm going to hand you next what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
Yes.
What is that?
That is a cash expenditure voucher.
And when you say cash expenditure voucher, tell us what that is specifically.
Yes. Anytime we spend any money to purchase illegal narcotics, we do a cash voucher to document where the money we're using is going to. This one in particular is $120 for the deal at Joey Fender's house.
And is that on June 29th and 24th?
Yes, ma'am.
Next, going to hand you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize that?
Yes, ma'am.
And what is that?
This is an informant payment cash voucher. This shows the fake name of JoJo. This shows where we paid Bobby Gibson $200 to complete this deal on June 29th, 2024.
And where was this deal set to take place?
At Joey Fender's house.
And what's her address?
129 Bell Street in Hillsborough, Ohio, Highland County.
Now, we've talked a bit about an audio and video recorder, and you actually watched that live as it's happening.
Yes, ma'am.
Do you also download the video from the recorder?
Yes, ma'am.
Next going to hand you what's previously been marked as State's Exhibit 6 for identification purposes. Do you recognize that?
Yes, ma'am.
And what is that?
That is going to be the surveillance video of the deal at Jody Fender's house on 6/29 of 24.
And again, you were watching this live as it happened?
Yes, ma'am.
And who are we going to see and hear on the video?
You're going to see Bobby Gibson operating the audio video recorder. You're going to see Joey Fender, and you're going to see Chris Burns, and you're going to hear Bobby Gibson talk to another female who was not shown on the video, who was in a car, I believe, out in the parking lot.
Now, did you recognize the people on the video as you saw them?
Yes, ma'am.
And is this a true and accurate copy of the video from the deal on June 29th and 24?
Yes, ma'am.
At this time, I would move to admit and publish State's Exhibit 6 for the jury.
All right.
No objection.
You may do that.
Detective Butler, as you watch this, I'm going to stop at a few points and ask you to explain to us what's taking place.
Yes, ma'am.
Can you see the TV?
Yes, ma'am.
there? I have to stop it. We were at 24 seconds, I believe. All right. I'm going to move on to some other questions loaded on the computer. You got me what's doing that. After the deal takes place, do you meet with Investigator Brewer again?
Yes, ma'am.
And was the CI searched again at that time? Was
Yes,
Bob
ma'am.
Wilson searched again? And who searched him after the deal took place?
I searched him, ma'am.
I'm going to hand you, when you met with Investigator Brewer and the CI after the deal, did you observe the substance that was purchased at the deal?
Yes, ma'am.
And I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize that?
Yes, ma'am.
And what is that?
That would be the 2 8-balls or 2 1/8 ounce or total should be 7 grams of methamphetamine. Justin Brewer was processing it when I met with him.
If it's less than 7 grams, would that surprise you?
No, ma'am.
In your work as a task force agent, have dealers shorted you before?
Yes, ma'am.
Now, once you and Brewer received the bag, did you ask BCI to test the bag for fingerprints?
No, ma'am.
Why not?
BCI won't test the baggies for fingerprints. Also, our CI's fingerprints would have been on that bag as well because they do not wear gloves.
Could you see, as you were watching the video live, could you see people handling the bags?
Yes, ma'am.
Who?
I saw Christopher Burns and Joey Fender and the CI all handling the bags.
Did you ask BCI to test the bags for DNA?
No, ma'am.
Why not?
BCI will not do DNA for drug cases. At the same time, too, our CI's DNA would have been on those baggies.
After you watched this video, did you are you able to take still pictures from the video?
Yes, ma'am.
And how do you do that?
It's like taking a screenshot on your phone as I'm watching the video live. It's like the top button and the power button at the same time, and you can screenshot what you're seeing on your phone.
And did you take pictures, still videos from this particular deal?
Yes, ma'am.
I'm going to hand you what's previously been marked as State's Exhibit 7 for identification purposes. Do you recognize that?
Yes, ma'am.
And what is that?
That would be Chris Burns, Joey Fender taking something out of his hands.
Is that a screenshot
Yes.
of something that took place during the deal?
Yes.
And in relation to the deal, do you recall when that happened?
That would have been after Joey directed Chris Burns. Bobby Gibson said he was there for 2 8-balls. Joey Fender said it's over there. At which point Chris Burns goes over to the dresser area, comes back and hands a black pouch and another item in his right hand, and the black pouch in his dark-colored pouch in his left hand, and hands them to Joey, and Joey takes it from him.
And you dealt the picture and took it right then?
Yes, ma'am.
And is that a true and accurate depiction from the video on June 29th, 2024?
Yes, ma'am.
I'm going to have to restart the computer. It's just spinning.
What?
I'm going to have to restart the computer. It's just spinning.
It's either that or smash it with my gavel. So,
Either way.
okay. Can't get it, we're going to move on. Move on.
During the video, as you watched it live, what did you see?
I see Bobby Gibson. He goes into the house. He makes contact with Joey Fender and Chris Burns. Bobby Gibson said he wanted 2 8-balls. Joey Fender said it's right there, at which point Chris Burns reaches over toward the dresser area. He hands Joey 2 items. One seemed like it was a little baggy in his right hand. The other one was like a pouch, like a dark colored pouch. Hands them to Joey. Joey walks on the other side of the bed and turns around the corner. She starts talking about scales, and she said, "There they are, Cebu, right there," referring to Chris Burns. Chris Burns goes over to the dresser area again under some clothes, I believe. You can see him with the scales in his hand and hands them in Joey's direction. Later, you see Joey with the same dark-colored pouch pulling the methamphetamine in and out of it, and from this baggie that she gives part of it to Bobby Gibson, and then Bobby Gibson leaves and meets up with Investigator Brewer.
And you watched all of that as it happened?
Yes, ma'am.
And you heard the conversation as it happened?
Yes, ma'am.
And who handed the substance to Joey Fender?
Chris Burns.
And who handed the scales to Joey Fender?
Chris Burns.
No further questions.
Cross.
Thank you. So, confidential informants get some consideration for the work, is that right?
How so, sir? I don't understand the question.
They're compensated, or they're able to work off charges.
Yes, sir.
And that's pretty standard for confidential informants.
Yes, sir, it is.
There are certain rules that the CIs have to go by, is that right?
Yes, sir.
And would one of those rules include not getting into additional trouble?
Yes, sir.
And would one of those rules also be to be honest with you?
Yes, sir.
I have a note here. I believe you testified that Bobby Gibson had set up, prior to communicating with you, the deal with Joey Fender. Is that right?
It had already been set up by the time we met with him.
You didn't direct Bobby Gibson to set up this?
That particular deal, no.
And I believe in what's been marked States Exhibit 7. That's a still video, or still picture of the video that you took as a screenshot.
Yes, sir.
And it's your testimony that whatever he's providing here is either the meth or the scales, or?
Yes, sir.
Okay. Can you say that with certainty?
It's the same consistency in the dark-colored pouch that's in his left hand that Joey Fender is later pulling the meth in and out of.
No further questions at this time.
Direct.
Yes, may I approach?
Mr. Walter asked you about States Exhibit 7.
Yes.
What is this?
This is Chris Burns handing the items to Joey Fender.
And what items?
There was a dark-colored pouch and another, looked like a corner of a baggie was in his right hand, and he hands both of them to
And what did
Joey
she do with
Fender.
the pouch after he hands it to her?
The pouch, when she goes over on the other side of the bed, and she's later seen pulling the methamphetamine in and out of the same bag that went toward the bag that she gave to Bobby Gibson.
Thank you. No further questions.
Thank you, Commissioner. Your next witness.
We move to admit our exhibits except for 6, and we would rest.
All right. Counsel, you want to approach, please? And then we can send them to lunch, and then we can do your motion. Lunch, there's a couple of legal matters we need to attend to outside of your presence, and rather than hold you here while we do that, we'll go ahead and adjourn now, and have it 11:31, so we'd like to be back about 12:40. When you do report to the jury room during the lunch hour, remember the instructions of the court, observe all the instructions I gave you about not discussing the matter with anyone or each other, not trying to find any other information, everything that I told you. You'll be excused now and return back at 12:40. Thank you. I'll be right back, Council.
Please rise.
All right, let me see, please. State has rested and, moved mission exhibits and then resting upon that ruling. Are there objections to any of the exhibits, Mr. Blosser?
No, Your Honor.
All right, all of those exhibits 1 through 7 will be admitted.
I did admit 6, Judge.
Pardon me?
6. I said with the exception of 6.
Well, it's admitted for the record, but it's not going to go to the jury.
Okay.
Yeah, we already admitted it when you published it. All right, it won't go to the jury, though. All right. Now, Mr. Blosser, I assume you want to make a Rule 29?
Yes, Your Honor. When viewed in a light most favorable to the state, it's our belief and our motion would be for an acquittal that there's not enough evidence of the 2 counts, previously 5 and 6, now 1 and 2, to be submitted to the jury.
All right, Ms. Collins.
Thank you, Your Honor. I believe the evidence is sufficient for finders of fact to make differing conclusions, and therefore it is a question for the jury. As scant as Mr. Gibson's testimony was, but Ms. Fender's testimony and Detective Butler's testimony all agreed that the defendant was directed to get the dope from the dresser. He handed it to Joey. It was in a black pouch and in a separate baggie. She takes the black pouch around the corner, pulls out the meth, weighs it out. He hands her the scales to weigh it out, and then she hands it to Bobby Gibson. So I think based on all of that, the jury could reach the conclusion that he is guilty of all facts, and therefore it should go to the jury.
Well, based on the fact that the state's primary theory of guilt is complicity, and looking at the definition of that, aiding and abetting, the court will find that it's a question for a jury as to whether the evidence is sufficient to prove beyond reasonable doubt the guilt, and reasonable minds could differ, so the court will overrule that. All right. Now we'll break for lunch, and you were going to discuss whether or not you're going to put on the evidence. Do you know at this point?
Yes, sir. That's another conversation we're going to have here just momentarily.
All right. Okay. Now, once they've gone to jury instructions, I think what I'm going to do, I'm going to reformat these. I'm going to put the instruction on complicity under each count before the findings, so that it's clear that they have to either find as a principal or as an accomplice. And I'm going to add a little bit of additional language to that instruction, which appears on page 12 right at the moment, and that's going to be inserted after the explanation of the elements of the principal offense. And what I'm going to put is that under the complicity, it starts off with saying the state of Ohio has presented a theory. What I'm going to say is that the law of Ohio allows a person charged with offense to be convicted either as a principal or if they were complicit in the commission of the offense. And then it goes on to explain that.
Judge Robert? I'm sorry, go ahead.
And then I'm also going to indicate that the elements of complicity must be proven beyond reasonable doubt. Okay.
A few things while we're looking at that section, the complicity section.
Yeah.
You have a person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he or she personally performed every act. This is true even if she did not. Never mind. When I read it out loud, it makes sense.
I was going to say that's cut paste right from the OJI.
Well, at first I thought it was reading that they had to personally perform, but it doesn't.
Yeah, okay.
And then also I did want to point out to you that at the beginning where you talk about Joey testifying, you call her a him.
Okay.
Page 3.
Page 3. All right. Oh, yeah, his. Yeah. I'll make it his or her. Try to do that so I don't have to change it every time it comes up. All right. Any other thoughts on the jury instructions or objections at this point, Mr. Blosser?
No, Your Honor. Thank you.
Well, we'll have another opportunity to review those, make any objections or requests after all the evidence is presented.
Yes, sir.
All right. Thank you.
Thank you.
Drive back to 1240.
Please rise.
Oh, wait a minute. All right, ladies and gentlemen, the state rested. The court did admit the exhibits that were discussed during the trial, and my understanding the state or the defense is not going to present any evidence.
That's correct, Your Honor.
All right, so that means that the evidence is completed now, ladies and gentlemen, so the court will instruct you regarding matters of the law. Then you'll hear the closing arguments of counsel, and then the final instructions from the court regarding your deliberations. Now, ladies and gentlemen, you have heard the evidence. It's the duty of the court to instruct you now as to the matters of law. Court and the jury have separate functions. If you decide the disputed facts, the court provides the instructions of law. And ladies and gentlemen, it's your sworn duty to accept these instructions and to apply the law as it is given to you. You're not permitted to change the law or to apply your own conception of what you think the law should be. Now, all criminal cases begin with the filing of an indictment. The indictment informs the defendant that he or she has been charged with an offense, and the fact that it was filed may not be considered by you for any purpose. Now, the defendant has entered a plea of not guilty, which is a denial of the charges and puts in issue all of the essential elements of the two offenses. Now, the defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offenses charged in the indictment. Now, reasonable doubt is present when the jurors, after they have carefully considered and compared all of the evidence, cannot say they are firmly convinced of the truth of the charge. It is a doubt based on reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending upon moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of that person's own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witness. You will apply the test of truthfulness that you apply in your daily lives. Now, these tests include the appearance of each witness upon the stand, their manner of testifying, the reasonableness of their testimony, the opportunity that they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest, and bias, if any, together with all the facts and circumstances surrounding their testimony. Applying these tests, you'll assign to the testimony of each witness such weight as you deem proper. You're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. Now, you will determine what testimony is worthy of belief and what testimony is not worthy of belief. Now, each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during the trial, counsel was able to inquire into some matters that did not directly relate to the issue before the court. Those questions and answers are permitted for purpose of helping you determine the credibility and the weight to be given to the testimony for no other purpose. Now, you have heard testimony from Joey Fender, another person who is accused of the same crime charged in this case and said to be an accomplice. An accomplice is one who knowingly joins another in the commission of the crime. Whether Joey Fender was an accomplice and the weight to be given to her testimony are matters for you to determine from all the facts and circumstances in evidence. Now, the testimony of an accomplice as supported by other evidence does not become inadmissible because of his or her complicity, moral turpitude, or other self-interest, but the admitted or claimed complicity of a witness may affect his or her credibility and make his or her testimony subject to grave suspicion and require that it be weighed with great caution. It's for you as jurors to, in the light of all of the facts presented to you and from the witness stand, to evaluate such testimony and determine its quality and its worth or lack of quality and worth. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide you to help you arrive at a just verdict. However, as with other witnesses, on you alone rests the duty of deciding what weight should be given to the testimony of the experts, and in determining its weight, you may take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, it's not necessary that the defendant take the witness stand in his own defense. He has a constitutional right to not testify. The fact that the defendant did not testify must not be considered for any purpose. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits that the court has admitted in evidence during the trial. Now, evidence may be either direct or may be circumstantial or may be both. Direct evidence is a testimony given by a witness who has seen or heard the facts to which they testify, and it includes, of course, the exhibits admitted into the trial as evidence. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically follow according to the common experience of humankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found to have been established by direct evidence. Whether an inference is made rests entirely with you. Now, when considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So, in other words, you can't stack one inference upon another inference to reach a factual conclusion. Now, where the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that the defendant is guilty. Now, the evidence does not include the indictment, so you won't have that with you, the opening statements or closing arguments of counsel. Opening statements and closing arguments, as I've indicated previously, are designed to assist you, but they're not evidence. And if there were any statements that were stricken by the court and you're told to disregard, they're not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question may have been had it been permitted to be answered. You must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. Now, a number of exhibits have been introduced, and testimony relating to them has been introduced and admitted into evidence. I think there are 7. And you may consider whether those exhibits are the same objects and the same conditions they were originally, and you will determine what weight, if any, each exhibit should receive in light of all the evidence. Now, the law under which the defendant is charged in count 1 is entitled Aggravated Trafficking in Methamphetamine and is numbered Ohio Revised Code section 2925.03A1. And this law states in pertinent part, no person shall knowingly sell or offer to sell a Schedule II controlled substance in violation of section 2925.03A1. So before you can find the defendant guilty, you must find without a reasonable doubt that on or about June 29, 2024 in Highland County, Ohio, the defendant did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance. So the essential elements of that offense of aggravated trafficking in methamphetamine as charged in count 1 of the indictment are as follows. 1, the defendant knowingly. 2, did sell or offer to sell. 3, methamphetamine, a Schedule II controlled substance. And 4, it occurred in Highland County on or about the date alleged in the indictment. It's not necessary the state prove it was committed on the exact day as charged in the indictment. It's sufficient to prove it took place on a date reasonably given date claim. Now, before you can decide whether the state of Ohio has proved beyond a reasonable doubt all the essential elements of the offense with which the defendant is charged, you must first decide whether this is the correct county in which this trial should be held. The state must prove beyond a reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, a person acts knowingly, regardless of his purpose, when he's aware his conduct will probably cause a certain result or is aware his conduct will probably be of a certain nature. A person has knowledge of circumstances when he's aware that such circumstances probably exist. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there existed at the time in the mind of this defendant an awareness of the probability the defendant's actions would cause a certain result or be of a certain nature. Proof of motive is not required. The presence or absence of a motive is one of the circumstances bearing upon purpose or knowledge, but where an act is a crime, a good motive or purpose is not a defense. Various chemical compounds subject to government control are called controlled substances and are placed in various categories or schedules by the Ohio Revised Code. Methamphetamine is a Schedule II controlled substance under the law. Sale includes delivery, barter, exchange, transfer, or offer thereof, and each such transaction made by any person, whether as principal, proprietor, agent, servant, or employee. Offer means to present for acceptance or rejection. Now, the state of Ohio has presented a theory that the defendant acted in complicity with the principal offender in the commission of the offenses charged in the indictment. A person who is complicit with another in the commission of a criminal offense is regarded as guilty as if he or she personally performed every act constituting the offense. That is true even if he or she did not personally perform every act constituting the offense or was not even physically present at the time the offense was committed. So before you can find the defendant guilty of complicity in the commission of count 1 as charged in the indictment, you must find beyond a reasonable doubt that on or about June 29, 2024 in Highland County, Ohio, the defendant knowingly aided or abetted Joe Offender in committing the offense of aggravated trafficking of methamphetamine as charged in count 1. So before you can find the defendant guilty of complicity by aiding and abetting of count 1, you must find beyond a reasonable doubt that the defendant supported, assisted, encouraged, cooperated with, advised, or incited the principal offender in the commission of the offense, and the defendant shared the criminal intent of knowingly of the principal offender. Such intent may be inferred from the circumstances surrounding the offense, including but not limited to presence, companionship, and conduct before and after the offense was committed. The mere presence of the defendant at the scene of the offense is not sufficient to prove in and of itself that the defendant was an aider or abetter. It is no defense to a charge of complicity that no person with whom the defendant was allegedly in complicity has been convicted as a principal offender. The defendant could not be found guilty of complicity unless the offense was actually committed based upon the state's proving the elements of the offenses as previously set forth in these instructions regarding count 1 and later count 2. Now, the definition of knowingly and of the existence of motive and how you determine that I gave you previously on the instructions on knowingly apply under complicity as well. Now, if you find that the defendant proved beyond a reasonable doubt all the essential elements of the offense charged in count 1 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense charged in count 1 of the indictment, your verdict must be not guilty as to such offense according to your findings. Now, if you find the defendant guilty of the offense charged in count 1 of the indictment, then you will need to make an additional finding beyond a reasonable doubt as to the amount of the amphetamine that was involved. And you'll determine whether the amount involved was equal to or exceeding the bulk amount but less than 5 times the bulk amount. And if your finding is not guilty, you make no finding on the amount of the drug allegedly involved as to this issue. Now, under Revised Code 2925.01, bulk amount of methamphetamine is defined as 3 grams. Now, the law under which defendant's charge in count 2 is entitled aggravated possession of methamphetamine, and it's numbered Revised Code section 2925.11. And that reads in pertinent part, no person shall knowingly obtain, possess, or use a controlled substance. So the defendant's charged in count 2 with aggravated possession of methamphetamine under that section. And before you can find the defendant guilty, you must prove beyond a reasonable doubt that on or about June 29, 2024 in Highland County, Ohio, the defendant knowingly obtained, possessed, or used methamphetamine as Schedule II controlled substance. So the essential elements of the crime of aggravated possession of methamphetamine as charged in the indictment, in count 2 of the indictment, are as follows. That the defendant did knowingly 2 obtain, possess, or use 3 methamphetamine, a controlled Schedule II controlled substance, and 4 the offense occurred in Highland County, Ohio on or about the date alleged. So the instructions that I read earlier pertaining to count 1 also pertain to count 2 as to the definitions of time and venue, meaning the place of where the prosecution can take place, the definition of knowingly, motive, and so forth. Those are all applicable. Now, the definition of possess. Possession of methamphetamine is an essential element of the offense of aggravated possession of methamphetamine. Possess or possession means having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of premises upon which the thing or substance is found. Possession is a voluntary act. If the possessor knowingly procured or received the item or was aware of his control thereof for a sufficient period of time to have ended his possession. A person has possession when he knows the object on or about his person or places it where it is accessible to his use or direction and has the ability to direct or control its use. Possession may be constructive. Constructive possession exists when an individual is able to exercise dominion or control over an item even if the individual does not have the item within his immediate control. Dominion or control may be established by circumstantial evidence alone. To find that an individual constructively possessed an item, the evidence must also demonstrate that an individual was conscious of the presence of the object, although a defendant's mere proximity is in itself not insufficient to establish constructive possession. Proximity to the object may constitute some evidence of constructive possession. Thus, the presence of the individual in the vicinity of the item, coupled with other facts probative of dominion and control, may establish constructive possession. 2 or more persons may have possession if together they have the ability to control it exclusive of others. Ownership is not necessary. A person may possess or control property belonging to another. So the definition of controlled substance I gave you applies, and the definition of complicity as to count 2 applies the same as it does in count 1. So in order to convict the defendant, if you do, of complicity, you must find that as to count 2, that on or about June 29, 2024 in Highland County, Ohio, the defendant knowingly aided or abetted joint offender in committing the offense of aggravated possession of methamphetamine as charged in count 2 of the indictment. And the same definition that I gave you earlier as to aiding and abetting and knowingly apply to count 2 as well. Now, if you find that the state proved beyond reasonable doubt all the essential elements of count 2 of the offense charged in count 2 of the indictment, your verdict must be guilty as to such offense according to your findings. If you find the state failed to prove beyond reasonable doubt any one of the essential elements of this offense charged in count 2 of the indictment, your verdict must be not guilty as to such offense according to your findings. And like in the first count, if and only if you find the defendant guilty of the offense charged in count 2, will you then make the additional finding as to the amount of the methamphetamine that was involved. And again, you'll determine if your verdict is guilty, whether the amount involved was equal to or exceeding the bulk amount or less than 5 times the bulk amount. And if your finding is not guilty as to count 2, you make no finding on this issue. And again, bulk amount is the same in count 2 as count 1. Under 2925.01 Advice Code, it is 3 grams. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and evidence applicable to each count separately, and you must state your finding as to each count uninfluenced by your verdict as to any other count. Then it may be found guilty or not guilty of either or both of the offenses charged in the indictment. Now, that completes the substantive legal instruction on the substantive matters. Just so you know, once I made some corrections, as you see that I found some errors in, I'm going to send a copy of this back with you when you deliberate, so that you won't have to try to remember everything I've told you. I don't know how anybody could, even 12 of them together. But this way, you can refer to that if you need to. Okay, now, at this time, we're going to hear the closing arguments from the attorneys. Closing arguments are not evidence, but they are simply the attorney's view and argument as to what they believe the evidence has or has not shown in the case, and they are offered for that purpose and no other purpose. The state, since it has the burden of proof, has the right to argue twice, once first and then after the defense in rebuttal. And so at this time, Mrs. Collins, you wish to make your opening portion of your closing argument.
May it please the court, Mr. Blosser, ladies and gentlemen of the jury, I first want to thank you for your time and attention to the case. We are one of the few countries that uses a jury system to decide guilt, and it only works with people like yourselves who take your service seriously. And for that, I want to thank you. As the judge said, I have 2 opportunities to address you, so I'm just going to keep the first one short and to the point. In June of 24, investigators Justin Brewer and Detective Brian Butler met with Bobby Gibson, who wanted to work with the task force. Task force members went over the process of buying meth with Bobby, and he provided the task force with the names of people that he could buy meth from. One of those people was Joey Fender. On June 29th of 24, Bobby made contact with Joey and told her he needed 2 8-balls of methamphetamine. Joey asked Bobby to come to her house. Investigator Brewer drove Bobby to the house on Bell Street in Hillsborough in Highland County. Bobby entered the house with an audio and video recorder and the pre-recorded buy money. He went to the house, and at that point, Joey instructed the defendant, Christopher Burns, that the meth was on the dresser. The defendant picked up the bags, a black pouch and another small bag, and handed them to Joey. Joey then went to the other side of the room and asked the defendant to get her the scales so that she could weigh the meth. The defendant looked until he found the scales, and then he walked them over to Joey. Joey finished weighing the meth and handed it to Bobby. Bobby paid Joey, and he left the house. He got back into the car with Investigator Brewer, handed the bag of meth Investigator Brewer the bag of meth that he had gotten from Joey and that Joey had gotten from Chris, the defendant. The meth weighed 5.90 grams, and the cost was $120. Ladies and gentlemen, there is no question that Joey Fender was selling methamphetamine. There's no question that Chris Burns assisted her in completing the deal. He was complicit with Joey Fender in trafficking in meth. There's no question that when he picked up the meth from the dresser, turned and handed it to Joey, he was in possession of that meth. When he then picked up the scales so that she could weigh out the 2 8-balls and hand it to Bobby Gibson, he was complicit in the trafficking of methamphetamine. Christopher Burns is guilty of trafficking and selling methamphetamine. Thank you.
All right, thank you. Mr. Blosser, on behalf of the defendant.
Yes, sir. May it please the court, counsel, ladies and gentlemen of the jury. First of all, we would echo our appreciation. This duty is not the easiest for people being asked to put your lives on hold. Thankfully, this is a one-day trial. There have been instances where we've had multiple days where people have been away from their jobs, from their friends, from their family. So thank you for that and for your attentiveness during the trial. Now, the state called, I believe, 5 witnesses, of which 2 of those 5 were present at that address, in that room. First one was Bobby. Mr. Gibson testified that he was there to buy meth off of his Fender, Joey. Now, again, nothing that I say during this closing, nothing that the state says during this closing is evidence. If anything that I say contradicts your recollection of what was testified, go with your recollection. Okay? I tried to keep detailed notes. A lot of times I'm being pulled in a number of different directions. Or my client is speaking to me, but when I heard Bobby, I don't know if he was clear. So I want you to keep that in mind, but also want you to keep in mind that 2 of those people that were present in that residence at that time that this incident allegedly occurred, both are receiving consideration for testifying, involved in this case. Now, she doesn't know what that would be, but that doesn't change the fact, nonetheless, that she has a vested interest in telling a particular narrative. The judge just gave you instructions on how to determine how credible a witness is. And I'm going to encourage you to take that to heart. And you'll have a copy of that also back in the jury. Joey Fender is getting consideration for testifying. Bobby Gibson received compensation, but previously had worked off charges. Third person that's present there is a person that does not have to testify and has chosen not to, has chosen to have the state prove him guilty beyond a reasonable doubt. And the judge explained to you what reasonable doubt is. And again, you're going to have that with you back there. But I'm going to tell you basically, it's not that he's possibly guilty. It's not that he's probably guilty. It's not even likely that he's guilty. It's beyond a reasonable doubt. So, as the judge said in his instructions to you, sorry about that, microphone. If you don't find all the essential elements, if you don't put together the bookcase, the way that the instructions tell you to do it, as distasteful as it may seem to you, if you find that it's not beyond a reasonable doubt on every one of those elements, you must find Mr. Burns not guilty. And not likely, not possibly, beyond a reasonable doubt. Folks, it's just the two counts here. At the end of the day, despite two people who testified for the state who were present during this alleged incident, you were going to be the ones that determine what happened, based upon the testimony of the witnesses. Ms. Farley testified, we're not saying that this isn't a substance, a controlled substance. We're not saying this isn't meth. But she couldn't tell you how she came to get that, obviously, right? I mean, she was just tasked with testing it. We talked a little bit about Bobby Gibson, a little bit about Joey Fender, okay? And she testified. And again, your recollection is different. Please go with your recollection. But I wasn't entirely clear on what she was saying at times. Granted, I had to go a number of different directions. We had the investigator, Mr. Brewer, Investigator Brewer. He just drove the CI, or confidential informant, to near Joey Fender's home, and then he walked the rest of the way to the home. And then we heard from Detective Butler, who was able to watch the proceedings on his cell phone live as it was occurring. And in fact, you'll have copies of the exhibits back there with you, but I want you to take a look at Exhibit 7. Because again, it's not entirely clear. Now, there was talk in voir dire, talk about circumstantial evidence and instructions that were read to you by the judge and will be provided to you. I want you to pay careful attention, and I'm sure that you will. I mean, you've been very attentive so far. But again, as I said in voir dire, every constitutional right that applies to Mr. Burns applies to you, applies to me, and each one is just as important as the last. Can't discount that. So I want you folks to take careful consideration, determine the credibility of witnesses by any bias, by any motivation that they may have. The things that you would use in your everyday. We talked in voir dire about, you hear something break and you walk in, the kids are like pointing at each other. You got to weigh that, okay? You got to weigh that against, to decide which child possibly broke the lamp. Maybe it was both. But folks, your jobs now become the most critical of anybody involved with this process. Then the lawyers and the court, your jobs are to determine the facts. And we are going to ask you that upon due consideration, that you find that the state failed their burden of proof beyond a reasonable doubt and find the defendant not guilty. Thank you.
All right, thank you, Mr. Lawson. Collins, we have the state.
So, yes, it's true that Bobby Gibson got paid for his work as a confidential informant. But don't we all expect to get paid for our work every day? And it is true that Joey Fender agreed to cooperate with the task force for consideration. She doesn't know yet what that consideration is going to be as part of her sentencing, But again, not uncommon. And what is also true, their recollection of events and what they told you happened perfectly matched what Detective Butler watched as the deal was taking place. He was watching it live, and what Bobby and Joey both said happened is exactly what Detective Butler exactly what he saw happen, and exactly what he testified to happening. And again, the defendant picked the witnesses. Joey Fender, Bobby Gibson, these are the people that he deals with. That's why we use Bobby Gibson to buy drugs. That's who this defendant, that's who Joey Fender deals with. So even if you ignore everything that Joey and Bobby said, Detective Butler watched the entire deal. He heard everything that was said. He watched it and heard it live as it was happening, and he testified to you and told you what was said and what he saw. The BCI chemist, Pam Farley, she's an expert in what she does. Her findings are recorded on the BCI report, and they're labeled States Exhibit 1. The report lists the result of the test, and it also lists the weight of the substance. It's not something that you have to remember. You will have the exhibit, so it's easy to tell. 2 bags tested positive as meth, and the weight right here to the side. You'll have this States Exhibit 1 in the jury room, so you don't have to remember that. We already spoke about Bobby Gibson. We already spoke about Joey Fender. Investigator Brewer of the prosecutor's office, he's assigned full-time to the task force. This is all he does. He drove Bobby to the deal. He collected evidence. He related to you. He's nothing to gain or lose by testifying here today. No bias. And finally, you heard from Detective Butler, who's assigned to the police department, who works at the police department, but is assigned full-time to the task force. His primary job is to assist in covert drug operations. He kept detailed notes of the buy as they were happening, kept the audio and video recordings, kept track of the buy money, collected all the evidence, and relayed everything to you today. Detective Butler was in the best position to see and hear what was happening during the deal. He's not standing in the room, so he's not trying to keep up with everybody else. He's watching as it's happening, and he's taking notes of what's happening. And again, you have that, the surveillance report that he testified to. Again, no interest or bias in the case. He's just relaying the facts as they happen to you. Let's look at the elements of the crimes charged here. Counts 1 and 2, and they just as the judge read some of the, he didn't read like every single element twice because they have so many elements that are saying like knowingly. Aggravated trafficking in meth and aggravated possession of meth. So when Bobby arrived at Joey's house, he goes in, he gave Joey $120. He said he laid it down. She said he laid it on the bed. Joey asked the defendant, and everybody agreed to this, everybody testified to this. When they walk in, Detective Butler recognized Chris Burns or Sebo in the room with Joey. Bobby Gibson says he walked in, recognized Chris Burns or who he knows as Sebo in the room. And Joey said, yeah, Chris Burns or Sebo is there. And Sebo is the nickname that they all call him. So they walk in and Bobby asks for the meth that he had previously ordered. Joey looks at the defendant, Chris Burns or Sebo, and says, get it off the dresser or hand it to me, it's right there. She said he handed it to her from the dresser. Detective Butler said, I saw him grab a black pouch and another little bag and hand it to Joey. And if you look at the picture of State's Exhibit 7, it's not super clear, but you can see the black pouch that Detective Butler was talking about. Grabs it off the dresser, turns and hands it to Joey. Bobby said he handed something to Joey. So Joey said, Bobby said, and Detective Butler watched and also saw the defendant hand a black pouch and another little black bag off the dresser to Joey. Then they all agree that Joey walks around to the other side of the room, sits down. Joey says it's a nightstand that she's sitting at. Sits down at the nightstand and she starts to weigh it out. But she needs the scales first. So she tells Sebo or Chris Burns, the defendant, get me the scales. Everybody that watched this, everybody that was involved agreed. He digs around on the dresser, he finds the scales, he brings her the scales, She weighs it out. She then hands it to Bobby Gibson. Bobby ties off the bag and he leaves the house. Joey testified to that. Bobby testified to that. And Detective Butler watched that and heard that. And then as it was happening, and he testified to that today. So, on or about June 29th, 2024, there's no real question. Everybody agrees that that is the date that this occurred at. 129 Bell Street in Hillsboro, the home of Joey Fender. Everybody agrees that that's in Highland County. Knowing, well, you can determine if a person acted knowingly by the events before and after. And I want you to keep this in mind. And it says that in your jury instructions. And I want you to keep this in mind. Joey, I asked Joey specifically, was this an uncommon thing, what happened this day? Or did the defendant come to your house regularly? And she said, almost daily, if not daily, every other day. And then I said, well, did he help you do this at other times? Yes, this was a regular thing that he did, helping weigh meth and this kind of thing. He's acting knowingly. This isn't the only time. He's not sitting there dumbfounded. He's actively involved in the deal. He's acting knowingly. Seller offered to sell. So Joey actually sets the deal up. No question about that. Bobby sets the deal up with her. Hey, can I get 2 8-balls, 3.5 grams each of meth each? 2 of those for $120. Yep, come back, pick it up. Absolutely, she set the deal up. But the moment that she says, hand it to me hand me the dope or hand that to me, and he turns around and grabs it from the dresser and turns and hands it, and that's what the picture is. That's exactly when he's handing it to her. He is participating, aiding and abetting her in completing the deal. And that's what's required. That's what the law says, and that's what your jury instructions say. So, no question that this is meth. $120 for 5.9 grams of meth. I already talked about it, States Exhibit 1. And it is a Schedule 2 controlled substance. That's on page 7 of your jury instructions. So based on all of that, no question that he's guilty. You then look at whether or not it's bulk amount, and this is important. It's the second part of your verdict forms. There's a place was or was not equal to or exceeding bulk amount. You know that the jury instructions say that bulk amount is 3 grams. It says that on page 10 of your jury instructions. So since it does say that, there's no question the BCI number 1, or I'm sorry, the State's Exhibit number 1, which is the BCI report, will tell you that it's 5.9 grams. Clearly that's greater than 3 grams, so it equals or exceeds bulk amount. And again, it's on your jury instructions. You don't have to remember this. It says it right in your instructions. Now let's talk about the possession. This is really kind of almost too simple. Clearly, we've already established on or about June 29th of 24 in Highland County, knowingly obtain, possess, or use. Again, the moment that he grabs it off the dresser and turns and gives it to Joey so that she can complete the deal, what's he doing? He's obtained it. He's possessing it. Right then, it's in his hand. It's actually in State's Exhibit 7. It's what Joey told you happened. It's what Bobby told you happened. And it is what Detective Butler watched happen as it was happening. So the defendant obtained, possessed, or used a controlled substance. 5.9 grams of meth, Schedule 2 controlled substance. Again, it's in State's Exhibit 1, the 5.9 grams of meth. So you find him guilty. And then again, greater than bulk amount. Is it greater than 3 grams? Bulk amount, according to the jury instructions, is 3 grams. This is 5.9, so it's definitely greater than 3 grams. I want to talk about the complicity and aiding and abetting. So your jury instructions say, a person is complicit with another in the commission of a criminal offense if regarded as guilty and is regarded as guilty as if he or she personally performed every act constituting the offense. This is true even if he or she did not personally perform every act constituting the offense or was not physically present at the time the offense was committed. So it doesn't matter, according to the jury instructions, that Joey is the one that said, I want $120 for 2 8-balls. The fact that he assisted her in completing the deal, according to the jury instructions, he is guilty of every act as if he performed it himself. Aiding and abetting. Before you can find the defendant guilty of complicity by aiding and abetting of either count, you must find the defendant supported assisted, encouraged, cooperated with, advised, or incited the principal offender in the commission of the offense, and that the defendant shared the criminal intent. Was he acting knowingly? Well, obviously he's acting knowingly. He looks for it, he turns, he hands it to her, then he's looking for the scales. Such intent may be inferred from the circumstances surrounding the offense, including but not limited to presence, companionship, and conduct before and after the offense was committed. Again, right there in your instructions, supported, assisted, that he only has to do one of those things. He assisted her in completing this deal. He acted knowingly. Again, Joey told you that the defendant was there almost daily, and he was there helping weigh out meth. Again, we talked about this in jury voir dire when the bank robbery scenario, when one bank robber goes in and he holds up the bank and he shoots the bank teller. The guy that's driving the car, the one assisting, is guilty of the murder that he's committed in the bank. There is an even closer connection between Joey and the defendant. They are standing in the same room together, so it would be the same as if the defendant was standing in the bank and handed Joey the gun to shoot the bank teller. That's what's happened here. They're standing in the same room together. He hands Joey the meth so that she can get it weighed out. Then he hands her the scales so that she can get it weighed out, so that she can complete the deal. The very last questions that I asked Joey was, did the defendant assist you in this deal by handing you the meth? She said yes. My very last question to her, did the defendant assist you with this deal by handing you the scales? Her answer was yes. Now, the state's proven each and every element of counts 1 and 2 beyond a reasonable doubt, with the additional findings that the amount of meth was equal to or exceeding bulk amount or 3 grams. Now, we must prove each and every element of the crimes charged beyond a reasonable doubt. And the defense would ask you to expand reasonable doubt to be some gigantic burden of proof that's completely overwhelming and could never be achieved. But the state welcomes that burden of proof, especially in a case where the facts and evidence are as overwhelming as in this case. And remember, reasonable doubt is doubt based on reason and common sense. It's not proof beyond any and all possible doubt. Let's talk about something that you might take on in your everyday life. Let's talk about buying a car. You want a used SUV and you want a red one, and your budget allows you to make a payment of $500 a month. So you look around and you find a red SUV that's exactly what you want. It only has 60,000 miles on it. The payments are going to be $485 a month. Now, this is everything you want in a vehicle, right? All the evidence points to you buying the vehicle. Now, is there some remote possible doubt that this is not the perfect vehicle? Yeah, there is. But reasonable doubt based on reason and common sense has been overcome, and you buy the vehicle. The same as in this case. Reasonable doubt based on reason and common sense has been overcome, and this defendant is guilty of both trafficking and possessing methamphetamine. Again, it's not your job to look for reasonable doubt. Had it been present, it would have presented itself in the evidence. It's just not there, ladies and gentlemen. Everyone testified. The facts of the case match from one person to another person to another person of exactly what happened in this case. Ladies and gentlemen, the state has proven each element of each crime in this case by proof beyond a reasonable doubt. And this is not a difficult case. Investigators Brewer and Detective Butler, they put the work into this, and I'm now asking that you simply review the overwhelming evidence, remember the testimony, and using your common sense, come to the only legal conclusion, the only conclusion that makes sense. This defendant is guilty of all counts as charged. Thank you.
All right, thank you, Ms. Thomas. All right, now, ladies and gentlemen, you've heard the closing arguments of counsel, which again, I'll remind you are not evidence. Now, I'm not going to instruct you on how to conduct your deliberations and prepare your verdicts once you have reached them. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all the evidence, decide all of the disputed questions of fact, apply the instructions of the court to your findings, and render your verdicts accordingly. Now, in fulfilling your duties, your efforts must be to arrive at a just verdict, so you should consider all the evidence and use your common sense and make your findings with intelligence and impartiality without any bias, sympathy, or prejudice, so that the state defendant will feel that their case was fairly and impartially tried. Now, during the course of the trial, the court has said or done anything you consider to be an indication of my views of the facts or the case in general, you're instructed to disregard it. That's not my function, and that's when I make rulings, that's not what the purpose of the ruling is. It's simply to rule on the issue, but not to influence your view of the case. Now, your conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate to change your position, even if you later decide that you may be or you are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement, if you can do so, without disturbing your individual judgment. You must each decide the case for yourself, and you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change your opinion if you find that it is wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinion of the other jurors. Now, you may not discuss or consider the subject of punishment. In the event you find the defendant guilty, the duty to determine punishment is placed by law upon the court. Now, when you go to the jury room, your first function will be to select one of your members as a foreperson, and that person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. The foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. Now, I will place in your possession most of the exhibits. I'm not going to give you the video because we don't have, if you need to replay that video, we'll have to bring you back and do it on the courtroom equipment. And the methamphetamine will not go to you either, just as a matter of safety purposes. If you feel you need to see it, you can bring it back and we can display it to you in the courtroom. But with that exception, the other exhibits and the verdict forms, the foreperson will have possession of those and return those to the court once you've reached a verdict along with your verdict forms. Now, until your verdicts are announced in open court, you're not to disclose to anyone else the status of your deliberations or the nature of your verdicts. Now, this being a criminal case, before it can be said that you've reached a verdict, it's necessary for all 12, and I'll repeat that, all 12 of the jurors to agree upon a verdict on each count. Now, you'll have in the jury room, in addition to the exhibits that I've said you'll have, that the court has admitted, and a copy of the instructions, 2 verdict forms. And they each look like this and have the name and case, and I've misspelled the name, so I'll have to fix that before I send it back to you. But it has verdict count, this one says count 2, and the other one says count 1. And you'll notice from there's a blank space. So what the verdict forms read is that we, the jury, duly impaneled and sworn, find the defendant Christopher A. Burns, and then there's a blank spot, and underneath that, or in there, is where you will write guilty or not guilty, as suggested by the language right below there. And then it says of the charge in count 1, aggravated trafficking in methamphetamine, and count 2, aggravated possession of methamphetamine. Now, as I further indicated, it has additional language, additional finding if verdict is guilty. That's in each count. And it says, we further find the amount of methamphetamine involved either was or was not equal to or exceeding bulk amount, but less than 5 times bulk amount. And so you strike out the words that do not apply. So if you find it was, and you'll strike out was not. If you find it wasn't, you'll strike out was. And again, if your verdict is not guilty, you do not need to fill that portion of the verdict form out. Now, once you've reached a verdict, you'll each sign your name in ink, all 12 of you. As I said, because all 12 of you have to sign, agree on a verdict. And your signature on the verdict form or forms indicates that that is your verdict and that you concur in the verdict of that form. Now, during the deliberations, you'll be in the jury room in the charge of the bailiffs. They're going to ensure your deliberations are not interrupted and will be your means of communication with the court. Now, bailiffs cannot answer any questions about the case or the law or anything of that nature. If you have a question or a request, you'll have some paper in there and some pens. You write it down, knock on the door, give it to the bailiff. and then they'll give it to me, and after I consult with the attorneys, I'll return a response to you in writing. One thing I can tell you is this. If you ask me about the law, I'm going to tell you the law about that is contained in your jury instructions, and if you, I may point the page out to you, but I won't restate the law, because all the law is in the verdict form if you have, or in the jury instructions if you have a question. Now, if you need some additional help, I may be able to answer it, but generally I'll be limited to what I can tell you to what's in the instruction. Now, once you've reached a verdict, knock on the door and inform the bailiff, and then we'll call the parties back in, and that may take a few minutes, and then we'll bring you into the courtroom to announce the verdict. Now, one thing I've neglected to tell you before lunch is that while you're in the jury room, you won't be able to have your cell phones or any other electronic device by which you can communicate outside. So if you would, just leave it back there on the sill, door sill above the register when you go in, and the bailiffs will keep an eye on it for you. But you can't have anything like that in the jury room. Now, I want to thank all of you for your patience and your attentiveness and your cooperation. The case has moved along very smoothly. And the attorneys have done a great job in presenting their cases expeditiously, but I think completely. And the important thing to keep in mind is that they were both given each their full opportunity to present their cases. Okay. Anything further from counsel?
No.
All right. Now, at this time, Mrs. Wright, Mr. Peabody, you are the alternates, and so thankfully nothing's occurred to any of the first 12 jurors, and so you're not going to be participating in the deliberations. Now, you'll be allowed to leave at this time. However, you're still going to be under your the instructions and your oath as a juror to follow those instructions. You're going to need to leave your phone with a number with the bailiff. And, if you want to go back to your residence or work, whatever you may, but don't, as I say in the old Westerns, don't leave town, because if something happens during deliberations and one of the jurors can't continue, then we'll need to call you. So we want you to be, within 20 or 30 minutes of the courthouse. Wherever you live will be fine. Because I've actually had that happen twice in my tenure as a judge, where we've had to call one of the alternates in. And so you won't be able to discuss the case or do any of the other things I told you not to do until you receive a call from the bailiff, which you will. Once there is a verdict, the bailiff will call you. And then at that time, you'll be released from your obligations. And if you wish to talk about the matter then at that time, you may. You're not required to. It's your own personal choice. So at this time, if you would just come around here and give your phone numbers to the bailiff, and then go downstairs to the clerk's office and get your pay vouchers. And if you need an excuse for work, he can give that to you too. Okay? Thank you. All right, ladies and gentlemen, then, at this time, if you would, like I said, retire to the jury room, leave your phones on the sill. I'll make the corrections on the jury instructions and the verdict form. They'll come back to you shortly, along with the exhibits that I mentioned that you'll have in the jury room. All right, thank you. Hey, Ben. Just keep those two over there, and then those are the ones you're going back. Make sure they're all there. Thank you. So here's the list. All right, we're back on record. State versus Burners. Counsel's present, defendant's present. Received a communication from the jury. Says we would like to see the video. And so my plan is to have them come back in. And I guess the problem before us is a damaged video. You think you have one now that's not damaged.
We know for sure that we have one that's not damaged.
Okay, so we'll need to have that one substituted for this one and marked as 6A. So you want to get an exhibit sticker marked at 6A, put it on there, and for the record, we'll be playing that in lieu of 6, which is damaged. So,
Your Honor, if I may, are we going to view the whole video in its entirety, or just...
That's what they said.
Published?
They said we would like to see the video.
I see.
And so I would say that's probably safer than trying to point out something in particular for one side or the other. So just let them see the whole thing, the way they,
I guess then, I would note just a brief objection that it would go past what was already published to them because we don't have the benefit of witness testimony.
Well, I would agree with that then, if that's your objection. And as I recall, that it stopped just shortly after the part where you had the what was supposed to be him handing the scales to her. That Officer Butler testified back. I think that's as far as it went, as I recall. Either that, or we can play the Exhibit 6 as far as it'll go. Maybe that's the safer thing to do. Play Exhibit 6, and it'll go to where it went.
Play it all.
Oh, it won't play it all now.
I couldn't get it to play it all when
Okay.
we were trying.
Oh, so that's what you were doing? Okay, it wouldn't play it all.
No.
Oh, okay. All right. Well, we'll put it up there, and at the point that we get that point where there's a passing of the things, which is what the still is. I do know that part was on there. I think that's about as far as we can go then.
Okay.
All right.
So, okay. Perfect.
So we'll play 6A as a substitute up to the point as closely as humanly possible, stopping it when it gets to that point.
Yes, sir. Thank you.
And basically, Mr. Blosser, maybe you and Ms. Collins can stand here together, and then as soon as you get to that point, you can have her stop it.
Sure.
And we protect the interest of your client. All right, bring the jury in, Mr. Reno. Going to view the video. One thing that happened is that the video that was submitted, that was played, had a defect in it apparently, and it stopped at a certain point. So and it wouldn't play at all. That's why she couldn't play it later. So we're only going to play. If we have a new one, we're going to play it up to the point where the one that you actually saw was played, which is part of the case. And then things after that won't be played. So, Ms. Collins, will you go ahead and start that, please? Okay. All right. That's the point at which you saw. So, ladies and gentlemen, we retire back to the jury room. Remember, consider not just the replay of the video, but all of the evidence that was presented. You may continue your deliberations. All right, we're back on record. The State versus Burns, 24 CR 141. The verdict. The jury is notified to bail to have a verdict. So, Mr. Moreno, if you would have the jury come in, please. Thank you. All right. Good to see you, folks. All right. I understand we have a verdict. Who's the foreperson? Okay. Francis, you have to handle the verdict. Hand the verdicts to the clerk, please. All right, Mr. Hodgson, if you would read the verdicts, please.
The Court of Common Pleas, Highland County, Ohio, State of Ohio versus Christopher A. Burns, case number 24 CR 141. Verdict, count 1, aggravated trafficking of methamphetamine, ORC 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher A. Burns, guilty of aggravated trafficking of methamphetamine as he stands charged in count 1 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times the bulk amount. In the Court of Common Pleas, Highland County, Ohio, State of Ohio versus Christopher A. Burns, case number 24, CR 141. Verdict, count 2, aggravated possession of methamphetamine, Ohio Revised Code 2925.03A1. We, the jury, having been duly impaneled and sworn, find the defendant, Christopher A. Burns, guilty of aggravated possession of methamphetamine as he stands charged in count 2 of the indictment. We further find that the amount of methamphetamine involved was equal to or exceeding bulk amount, but less than 5 times bulk amount.
Thank you, Mr. Hodgson. All right. Ladies and gentlemen of the jury, you've heard the reading of the verdict. It's signed, each verdict signed by all 12. Is this the verdict of each and every one of you as to each count? Anybody disagree? No one? All right. Wish the jury polled?
No, no.
All right. All right. Then the court will accept the verdicts and enter findings of guilty as charged in counts 1 and 2. Ladies and gentlemen, this will complete your service then for this trial. I didn't tell you earlier this morning, but once you're selected to serve as a jury, you're excused for the rest of the term. You're actually on the term as ends March the 31st. And back in the old days, when I was prosecutor, I remember one year during the summer, we had a couple people serving in 5 juries. And when I became judge, I said, that's way more service than is to be expected for your civic duty. So I instituted the rule that you serve one trial, you're done for the rest of the term. So you won't be subject to being called until 2027, because you're exempt next year too. Now, we have a computer program that regulates that. It usually works pretty well, but once in a while something slips through. So if you should get called next year in this court or any other court in Highland County, let us know and we'll have you removed. It doesn't apply to federal court, though, so hopefully you won't be subject to that. All right, so thank you again for your service. We appreciate it, and you go ahead and pick up your cell phones and stop down at the clerk's office for pay vouchers and your work excuses if you need them. Again, thank you. I'll be right back, Council. All right, back on record, the jury has been discharged. The defendant's been found guilty of counts 1 and 2. Given the defendant's previous history, according to the discovery, the court is going to go ahead and proceed with sentencing without a pre-sentence report. The counts 1 and 2 would be merged, and so which does the state wish to have the defendant sentenced on?
Count 1.
Okay, state elects count 1. All right. Anything from the state regarding sentencing?
Your Honor, we would ask the court to impose a term of incarceration and would note the defendant's prior criminal history, which includes at least 3 prior convictions for drug-related offenses, 2 prior trafficking charges, and then a possession charge that was to the level of an F2. So likely was selling that. Based on all of that, we would ask the court to impose a term of incarceration. Thank you.
Mr. Blosser, on behalf of the defendant.
Your Honor, thank you. As this court is aware, having sat through the testimony as well as the limited video, this was a situation where I'm not going to say it's the wrong place at the wrong time, but however, it is not necessarily the worst form of the offense. I'd ask the court to take that into consideration in determining an appropriate sanction.
Mr. Burns, is there anything you'd like to say?
I'd just like to apologize to the court and everyone in here for their time and, just apologize for my actions. I guess you're around the wrong crowd. You get what's coming. I can only work for it from here and go from there. But I appreciate everybody being here and taking the time out for this.
All right. Well, according to the prior history, 2011, you had a second-degree felony and received 2 years, which was a minimum. In 2026, you had 2 counts of trafficking F5s. You received 8 months on each, 16 months it says total. So you've had lower sentences in the past, and it seems you're still involved in this this business. And Ms. Fender has a long time history as well, so I don't think it's something where you're not aware of. My gut tells me, my experience tells me that you probably had more involvement in this than what we know about from the evidence, simply because of being associated with Ms. Fender and her history and your history. But in any event, you've been convicted of 1 charge. She entered plead guilty to 2 counts, and she did cooperate. And I believe the recommendation on that is 12 months on each one. But she was convicted of 2 counts and also was charged with 3. But it'll be the order of the court then that you be sentenced to a term of incarceration of 24 months. So we've got a jail time credit, Dan. Yes, Your Honor. 24 months. And according to the sheriff, you have 26 days of jail time credit. Now, upon completion of this sentence, it is possible the Adult Parole Authority may place you under post-release control for a period of up to 2 years. They don't have to, but they can if they do. Then you'll be supervised under the terms they set for that period. They choose up to 2 years, and if during that period of time they find that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for any one violation, up to a maximum of 12 months or half of your term for all violations. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution order, and if you don't do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, you'll be permitted to do community service in this county, be given credit for each hour you work and an hourly rate set by the court until you have worked that off. Now, has there been any change in your financial circumstances since I appointed Mr. Blosser to represent you? All right. The court will then find that you do not have the ability to pay the mandatory fine, nor will you in the near future, so that will be waived. Now, Mr. Burns, you do have a right to appeal the judgment, the verdict, and the sentence and the rulings of the court. If you wish, you must file that within 30 days of the sentencing entry being filed, which will probably be today. You have a right to have all of the papers that are in the file, as well as a transcript of the hearings that were held. And if you don't have the money to pay for those, then the court will provide those for you at no cost. You also have the right to have an attorney to represent you in the prosecution of that appeal, and if you don't have the money to hire one, the court will appoint one for you. And since I previously found you're appointed or entitled to appointing counsel, if you're not available to sign another form, by the time the appeal is filed, the court will go ahead and appoint counsel for you. Now, typically the attorney who handled the trial doesn't typically handle the appeal, but Mr. Blosser, if you would talk to Mr. Burns, if he decides to, what I would ask is that you at least file the notice, limited appearance, file the notice, and indicate that you won't be handling the appeal. If that, unless he wants you to, again, you can, but most of the time that doesn't happen. And if that happens, Mr. Burns, then the court will appoint another attorney to represent you on the appeal. The appeal will go to the 3 judges of the panel in the 4th District. It'll be strictly a legal argument thing. It'll be done by briefing and oral argument. There won't be another trial or another court appearance for that, but that's what will happen. All right. Also, what's the restitution in this case? $120?
Yes.
All right. It's ordered to make $120 restitution to the Hindley County Task Force, and that be payable through the Hindley County Victim Witness Escrow account. You'll be required to pay any service fees that are connected to that. And that is something that doesn't go away just because you serve your sentence. It'll always be a judgment against you. It could be subject to being collected after you get out of prison if you don't pay it. All right. Anything further?
A couple of things, Judge. Is that joint and several with Joey?
Yes, joint and several with Ms. Fender.
And then did you say no license suspension?
I did not say it, but no license suspension. Anything further, Mr. Nate?
No, Your Honor.
Anything further, Mr. Blosser?
No, Your Honor.
All right, you're remanded to custody, Mr. Burns.
Please rise.
Let me follow.